Hello, welcome everybody to this 42 Bedford Row Barristers webinar. We are going to talk to you this afternoon about proving the elements of an EPA prosecution. So my name is Iris, this is Andrew.
Hi everyone.
Hi. We're going to start with giving you a little summary of the elements of the offence, and then we'll go on and talk about some of the details together. Andrew, I'm going to start if that's okay. I've got a nice little summary here. Okay, there are 6 elements that you need to think about when you're considering your EPA prosecution or when you are defending your EPA prosecution. Number 1, are the premises in such a condition as to be injurious or likely to cause injury to health? That's the first point, the condition of the premises. The second requirement, is the defendant the person responsible for the condition of the property? Third requirement, is the prosecutor the person aggrieved? Those are the words used in the statute. It's a bit old-fashioned, but we know what we mean. Is the prosecutor the person aggrieved by the condition of the property? Then, number 4, has a notice of intended prosecution been served on the defendant? Number 5, has it been 21 days since the service of that notice of intended prosecution before the application to the magistrate's court? And then finally, is the nuisance still in existence on the date of trial? Okay, so those are our 6 elements. We're going to be covering each of those today. And I'm going to just start by taking you briefly through what the condition of the property requires. The statutory nuisance, as I said before, is that the condition of the property is injurious or likely to cause injury to health. That comes from Section 79 of the EPA. Section 79A, any premises which are in such a state as to be prejudicial to health or a nuisance. And you might think that that sounds like there are 2 different things going on. There's either injury to health or nuisance. But in fact, very long established case law means that even if you were to label this condition of the premises a nuisance, you would still need to prove that the condition was injurious to health. So in practice, do you ever see a nuisance being the limb that is relied on? I never see it. What you always see in the prosecution is that the state of the premises is prejudicial to health. That is the one that everybody always relies on because it's easier to prove. Okay. So, Andrew, you're going to say something now about what is prejudicial to health.
Well, the most common way that premises are prejudicial to health is in the context of damp and mould. And what you see is either a dispute between the landlord and tenant, where the tenant will say it's a structural issue or there's a leak somewhere, or the landlord will say, no, it's not anything to do with the structure, it's about the way that you're using the premises, tenant. So condensation mould is one of the big ones that we see.
So can I ask you a quick question on that? I know in my Section 11 disrepair cases, it matters if the condensation is caused by something being out of repair. If nothing's out of repair, then you can have all the condensation you like. It's not Section 11 disrepair. Is that how it works in EPA prosecutions as well?
No, it doesn't work in that way. So Section 11 it is directed to keeping in repair the external and the structure of the building, whereas what we're focused on here is prejudicial to health.
So it's a sort of outcome rather than the cause almost that we're focusing on. Is that right?
Exactly.
Okay,
exactly.
Gotcha.
So when we're talking about whether it's the tenant's fault or whether it's something that the tenant has done in the way that they live, which is causing mould, the first matter that you need to focus on is the factual one. If there is a factual dispute and it's proved that part of the mould is caused by the tenant, then you go to the question on causation. The question on causation is then about how much of the mould or the damp or the condensation is caused by what the tenant's doing and how much is by the nature of the property itself or some disrepair that's present within the property.
So it sounds a bit like a Section 11 disrepair in that sense, in that depending on whether it's the tenant's fault or not, you can, if you're a landlord, you can defend a condensation, mould and damp claim.
Yes.
Okay. If just quickly then, before you go on to the next bit that you were going to say, if the condensation, mould, damp is not for the tenant, do there have to be other investigations about the cause, or is that enough? Is it just the fact that there is damp and mould is enough to make the property prejudicial to health, as long as it's not the tenant that is at fault for that?
Yes, well, as we said before, it's outcome driven.
Right.
So the fact that the premises are producing the mould, and that the mould is to a level where there's prejudice to health, that is enough for liability.
Okay, so it sounds like the tenant's responsibility is important, and we might come on to that when we talk about some of the other elements of the offence as well. Okay, what about, I mean, you've told me about damp and mould, and I also see lots and lots of damp and mould cases. Are there any other types of situation that don't typically work as a Section 11 claim that you might see in an EPA prosecution? What about mice and rats and ants and bed bugs and things like that?
I mean, this is a
that's my favourite type of case.
It's the one that you take to that you read straight before you go to bed. But
absolutely, that's the dinner party conversation, isn't
Yeah.
it?
Of course, pests are an exemplar of prejudice to human health, and it certainly does meet the requirements if you can prove it by way of expert evidence, which we'll come on to. But there's plenty of cases on that.
Presumably, the reason that infestations of this kind work for EPAs is, again, because you don't have to prove the cause. As long as it's not the tenant's own fault, then the landlord is going to be responsible for resolving an infestation that is prejudicial to health.
Yes, and of course, the question around is it the tenant's own fault? Again, that's typically a matter which is ripe for dispute within these types of prosecutions. And one must bear in mind, of course, that we are in the criminal jurisdiction. The test or the burden is beyond reasonable doubt, or that the court has to be sure that the cause is, or that the person responsible is the landlord and not the tenant. So things like checking the photos to see if there's food left out, and what the experts are saying when they go to do their inspections, that's all going to be very important material. Okay.
But presumably, like with damp and mould, if it's not the tenant's fault, then it almost doesn't matter whose fault it is.
Yes, precisely.
You're going to have liability.
You could have a restaurant downstairs which doesn't throw its food away and has a nasty rat infestation. It would still be the responsibility of the landlord to ensure that proper proofing works were done.
Gotcha. Okay. What about, well, you've talked about the burden of proof being the criminal burden of proof. So I think you said this, but presumably that's a burden on the tenant, because unusually in EPAs, the tenant is the prosecutor. So you have to keep that in mind, that what you might think of as a claimant or institutional prosecutor in the form of a local authority might actually be the defendant in an EPA prosecution, because they happen to be the landlord of that property.
Yes. So the tenant is the prosecutor, and of course that means that there are all sorts of institutional requirements that are put on prosecutors. So the duty to act fairly, we'll come on to this, the duty to give full and frank disclosure, the duty to give disclosure in the first instance, and to disclose anything which might reasonably assist the defendant. All of these matters flow from the nature of the criminal proceedings.
Okay. And what about expert evidence? I think we're going to come on to the detail of expert evidence in a bit, but just generally in terms of establishing what the state of the premises is and whether the premises are injurious to health, prejudicial to health. Is that something you have to have expert evidence for, just to prove the state of the premises is like that, or can you get by without the medical evidence or the expert evidence?
Yeah, it's one of the major and only strong, hard evidential rules that apply in EPA prosecutions is that you need an expert to say this is injurious to health or this is prejudicial to health, because it doesn't simply flow that the existence of mold is injurious to health.
Why not?
Well, perhaps you might say that the mold is not of a kind that is prejudicial to health, or it's not of it to an extent that's prejudicial to health. These are all matters that must be proved, and the question of why not? Well, because the Court of Appeal tells us that we need to prove.
So can't the magistrates just say, well, okay, there isn't any expert evidence, but even though there isn't any expert evidence, we've seen the photos for ourselves, we find that it is prejudicial to health. Can they do that?
Well, I would be saying that in the absence of such evidence, the magistrates are not in a position to make that finding.
That comes from Southwark and Simpson, doesn't it? Our favourite case from 1999, which says that without the expert evidence, the magistrates are simply not in a position to decide the case. The burden of proof cannot be overcome without the expert evidence about whether the premises are prejudicial to health.
Yes, it's one of those, one of the few blunt rules, hard rules.
It's nice to have a straightforward rule with no exceptions. Okay, we like that. We've covered the fact that you have to have expert evidence, but it doesn't have to be a medical expert. It needs to be somebody who can give expert evidence about whether the premises are prejudicial to health. Yes. And we'll come back to the details of that when we talk about expert evidence generally in a little bit later. We're now going to talk about the person responsible. So you remember when we started, I said there were 6 elements to the liability test. First is the condition of the property. We've covered that now in some detail. The second is who is the person responsible. That has to be the defendant. And we're going to talk about that now. And then there are some other things that we're going to go on and talk about in a moment. So who is the person responsible for the condition of the premises? Is it the defendant or is it somebody else? The annoying answer to that is it's a question of fact. It depends. And there are as many circumstances of responsibility as there are cases. Every case turns on its own facts. But I did think that it would be good to give you an illustration from an unusual case and tell you the facts of that case so that you can see just how technical this part of the test can be about who is the person responsible. So in 1995, there was a case that got to appeal called Network Housing Association and Westminster City Council. It was unusual because it was a prosecution by the local authority rather than by an individual prosecutor. That's one of the things that the EPA allows. We tend to talk about cases brought by individual tenants, but it's also possible for a local authority to bring an EPA prosecution against somebody who's responsible for a nuisance, and that's what this case was. So Network Housing Association were the defendant, Westminster City Council was the prosecutor, and what had happened was that Network had acquired a building, which was a converted block of flats, and they had done some specific refurbishment work themselves, Network, after they bought the block. And one of the things they had done, one of the things that was in the specification of work was that they had laid sound insulation boards between the flats, above and below. 2 particular flats, flat A and flat B, were one above the other. And they were both let by Network Housing Association on 99-year leases. So they were long leases. Person in the flat below complains of noise from the flat above. Council serves the noise abatement notice, as it is for noise, on network, not on the person living above, because, and this is important, the person living above was doing nothing out of the ordinary. It was just ordinary household noise that the tenant in the flat below was hearing. And so the person that the council decided was responsible, remember we're talking about the test of the person responsible for the nuisance, the council decided that the person responsible was network because they had installed the soundproofing. They were responsible for its failure because they'd installed it. Network Housing Association appealed the notice. They said they were not the person responsible because the two flats had been let on 99-year leases. They had no right to enter either premises. They had no right to access the roof or the ceiling or the floor joists to access the soundproofing. What do you think happened? What do you think the court held on appeal?
One can't blame the tenant above, or the 99-year leaseholder above, for living in there and having ordinary noise of living. So it must be network.
And it was an important aspect that they had done the work,
yes,
that had established the soundproofing, which wasn't working.
Yes.
So they had taken responsibility for making the flats soundproof before they let them.
Yes.
And then they failed to do a good enough job,
yes,
to actually properly soundproof them. So I like that case because it's technical. It's about something else, about noise, not about injury to health. And we don't see those cases very often in our typical tenant-driven EPA prosecutions. But it does illustrate, as you say, the harshness of the rule and the technical nature of the rule. The court has to identify the person responsible. And once it does, if that person is the defendant, then that box is ticked and that point is established. And okay, I have another one for you, Andrew. This one is a bit more typical. What if I've got let's say I'm a landlord, and let's say it is one of our typical damp and mold cases. So it's a property with virulent, disgusting black mold all over the walls, definitely prejudicial to health. No question about it. No question of the tenant being responsible for it by virtue, for example, of the way they've conducted themselves in their tenancy, for example, by, say, not opening the windows or anything like that. So it's not their fault. Landlord is the person responsible. Let's say they've issued the landlord, you're the tenant, you've issued me with a notice of intended prosecution. So I know that you're going to take me to the magistrate's court, and I attempt to make arrangements with you to decant you into a travel lodge for a couple of weeks, because actually the work required to fix the nuisance is extensive and it would be unsafe for you to remain in place while all this mold was being sorted out. Okay, so I've asked you to move to the travel lodge and you refuse. Okay, you don't want to go to the travel lodge. What then? Who's the person responsible in those circumstances?
The rule is that that I'm the one who is the person responsible for the prejudice to my own health.
Because at the point, only from that point, right? And actually that's specified in the statute, that section 82(4)A. Unusually, there's a really specific rule about that. If the tenant is at fault because there has been an attempt to abate the nuisance which they have frustrated, then the landlord is no longer the person responsible. But at that point, the tenant becomes the person responsible. Let's go back. So that comes from a case of Quigley and Liverpool Housing Trust, which is a really nice case, and it tells you that that sort of scenario is straightforwardly going to move the legal responsibility, criminal legal responsibility, from the landlord to the tenant. Okay, now let's go back to what we touched on before, which was what if there is a suggestion that actually it's the tenant's fault for the mold, and we haven't really talked about that yet. So let's say I'm the landlord and I say, okay, yes, it's very moldy, but that is because you never open the windows. You have far too many people living in this flat, even though we've told you many times that you should not have all your mates to visit every day and parties every night. And you've got too much clutter in the house. There's no ventilation. you never open the windows, you never turn on the radiators, right? Does that mean that I have a dead-on defence, you cannot now win your prosecution?
Well, it depends on whether your expert will say that there's some other cause, that there's some cause of the landlord that is generating the mould and disrepair. Certainly, if you don't have an expert saying that, you won't get off the ground. That's, as we said before, you need expert evidence. But an assertion from a landlord, that you've treated the property in an untenant-like way, one just comes down to the facts. It's a factual dispute.
So presumably at the trial, there might be witnesses, there probably would be witnesses, you, the tenant, would say, no, I never do that. I always open the windows. I never have anybody round at all. And I always have the radiators on. Yeah. And then I'm the landlord and I bring along my contractor who says, but I visited 3 times in a week. And every single time all the windows were closed. The tenant had just taken a shower. The flat was extremely humid and there was absolutely no ventilation. She had all of her washing hanging up, all the wet clothes, and it was completely unventilated. So we would have a ding-dong between us about who's going to be believed. And that's going to be a question of fact.
Yes.
Right? So let's imagine I win that. Let's imagine that there's evidence and the magistrates accept that there is some untenant-like behaviour that is causing or contributing to the condensation. Is that it? Do I now win?
Well, so long as the magistrates find that at least one of the causes is the landlord, then under Section 82.5, it provides that where you have more than one person who is responsible, each of those parties are treated as the person responsible.
Oh, crikey. Okay, so that's interesting. So that surprises me. So actually, if it's partly your fault for always hanging out your washing and not opening the windows and never turning on radiators, but also let's say there's a leak and I haven't fixed it, and that's contributing to the humidity, and an expert says, actually, without the leak, there wouldn't be this mould, even with all of the clothes hanging and so on, I'm still going to be responsible.
Yes.
I'm going to be convicted.
Yes.
Okay. So expert evidence really is very important.
It is absolutely critical.
Okay. We better get onto expert evidence. I think before we get there, we've got to talk about the person aggrieved. So that's part 3. So we had state of the premises, number 1, person responsible, number 2, covered that now. Yes. And we've talked about all the different people who can be responsible, tenant, landlord, and so on. And now we're going to talk a bit about who is the person aggrieved, who can bring the prosecution.
So any person who has use of the land who is affected in consequence of the state of the premises, the condition of the premises, any of those people can bring the prosecution. Well,
okay. So what about let's say I've got a child that lives with me. I'm a tenant. Sorry, I'm now not a landlord. I'm imagining I'm the tenant. The child obviously isn't the tenant. The child is just an occupier with the tenant. Could they potentially bring a prosecution in principle?
In principle, a child could bring a prosecution. There's an open question about whether a child should be bringing a prosecution and the ways you would go about ensuring that the child, knew what they were doing,
But in principle, does the EPA allow it?
Yes, in principle, yes, a child could do it.
Okay. And then we would just, before we go on to talk about the procedures, which are important, we just make the point that the date that the magistrates have to look at in terms of when is the property injurious to health, at what point in time are they considering the condition of the premises? It's at the date of trial. That's the point at which the assessment takes place. Yes. If things have improved since an earlier time, that's relevant. If things have got worse since an earlier time, that's relevant. What is relevant is the condition of the premises at the time of the trial and the person responsible for that condition at the time of the trial. Yes. Right? That's important because things do change and landlords do try to gain access to do work and get stopped from doing so, and then things can change very significantly in terms of liability.
Yes, and it underlines the importance of the having updated expert reports. You need to be in a position, if your expert report is 2 or 3 years old because there have been delays because of COVID, of something else, you need to have someone come in and say, within a reasonable time of the trial date, yes, these premises are still affected by damp or mold, whatever it is, and they're still prejudicial to health.
So you're really building in an additional visit just before trial.
Yes.
To ensure that the expert evidence is up to date.
Yes. Yeah.
Okay, that sounds quite important.
Yes.
Because that's the point that you have to prove it at this date of trial.
Certainly. And it also underlines the importance of making sure that there's no unnecessary delay.
As much as you can control that,
as much as one can control it, yeah.
Okay, I think that's pretty clear. So we've talked about the condition of the premises, we've talked about the person responsible, we've talked about the person aggrieved, and we've talked about the timing, the fact that the condition of the premises and the person responsible must be proved at the date of the hearing. The other 2 elements, I'm sure you will remember, from the beginning of this session are the notice of intended prosecution and the date, the 21-day limit. So let's talk a bit, Andrew, about these practicalities. And Andrew, if I may, I know that you've done quite a few of these EPA prosecutions recently. So I'm ignorant. I would like to ask you some questions,
right.
And just help me out. Explain to me how the practicalities work. Okay. Right. So first of all, the notice of intended prosecution. What does it look like? Is there a standard form? Do you have to fill in a pro forma?
No, there's no standard form for notice of intended prosecution. All that needs to be in it is 1, that you intend to prosecute. Right. 2, that it needs to set out the nature of the statutory nuisance, and 3, it needs to set out the effect.
Effect on the prosecutor.
On the person.
The way in which they are injured by it.
Indeed, yeah.
Gotcha. Okay.
Yeah. So usually you want to include, of course, the details of the parties, the nature of the premises, or where the premises are, a statement that the letter, which usually will be a letter, is intended to be a notice of prosecution. So keyword is take notice that, and the date after which proceedings are going to be commenced against the defendant if there's no action or no response.
Okay, so I'm going to just tick those off again. So the things that I should have in my notice of intended prosecution, no particular form, but things I should have in there are the nature of the fact that it's a notice of intended prosecution,
yeah.
The nature of the nuisance,
yeah.
The effect of the nuisance on me, the address, my name as well, I guess. I think you said that, and the date of the proceedings. Okay, that seems straightforward.
Yeah.
Okay, fine.
And you need to leave 21 days. So you serve your notice of prosecution, you need to leave 21 days after service. And it's important that you can prove service, because it is a jurisdictional issue. You can't bring your application or for the summons without your notice of intended prosecution. So make sure that you get that right.
What is the time limit? Is it 21 days?
Yes, 21 days if it's about the state of the property, or it's 3 days if it's about noise.
Okay. So I give the notice, I wait for 21 days. Just for safety, I wait another couple of days. Then I go ahead and apply for the summons. Okay. So now I'm a landlord again, right? I have received a summons from the Magistrates' Court. You are my tenant. You have made the application for the summons. Tell me, are there any technical defences that I could be looking out for as a landlord, which might knock out this summons completely without me having to engage with a messy set of facts that might not flatter me?
There are some technical defences that you can run. One, that the time limit, the 21 days, hasn't passed.
Right. And that's where you say there has to be evidence of service.
So you need to be able to prove service, so the tenant needs to be able to prove service to rebut that knockout point.
Okay.
Second, the information in the summons needs to be sufficient to explain the nature of the charge, bearing in mind that these are criminal proceedings. And so
that sounds quite important.
Yeah, it's quite important. The specificity of the charge is of critical relevance and importance.
But what happens if it isn't clear what the details of the charge are?
Well, if it's not clear, there are potentially two options. One is that it'll get knocked out as being insufficiently clear, or two, the prosecutor will have to amend their summons, which as we said before, just builds in delay. It then enables the landlord more time to come and do the repair work, which is, I suppose, good in terms of avoiding criminal liability. But we're here to prove an offence, so we want it to be quickly. When it comes to the summons can be set aside as an abuse of the court's process under the authority of Liability. It's a 2021 case, and what it says is not only does it need to have sufficient particulars, but there's also a duty on the prosecutor to give full and frank disclosure. And what that means is, in this context, if you have given your notice of intended prosecution and the landlord comes back and says, well, look, it's not my fault because blah, 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 that is material that might impact on the decision of the magistrates to issue the summons. And so therefore it must be before the court when you apply for your summons. And if it's not, then you are liable to have your summons dismissed as an abusive process for failure to comply with the duty of.
And presumably then the costs that have been incurred up to that point are lost.
Yes.
Can never be recovered.
Yes, they're lost, they can't be recovered. And in fact, there's the potential for wasted costs.
That sounds pretty serious. So actually, if I think about the notice of intended prosecution as a bit like a letter before claim, I know it isn't like that, but let's imagine it's a little bit like that because it's a pre-issue document. And let's imagine that any response that is received following the service of the notice of intended prosecution is a bit like a response to a letter before claim. What you're saying is that at the point you issue the summons as a prosecutor, you have to provide both the information from the notice of intended prosecution and the information from the response to the notice of intended prosecution, a bit like setting out almost the contents of the letter of claim and the contents of the response to the letter of claim.
Yeah.
And if you don't do that, possibly you may get completely struck out if a landlord is savvy enough to realise that that's a knockout point.
Yes. Right. And that makes sense when you think about the nature of the proceedings that we're running in the first place. We're talking about criminal proceedings. They're brought by an individual, but just because they're brought by an individual doesn't make them like civil proceedings. It's just that an individual is acting as a minister of justice in the same way that the Crown Prosecution Service acts in that way, or a local authority acts in that way. The same obligations.
Pretty serious stuff.
It's a serious step to commence criminal proceedings against another person.
Okay, so I'm going to be looking out for that from now on, because that's probably something that does crop up sometimes, and perhaps landlords don't even realise it.
Yes.
Nice recent case, Siddiqui, 2021, and we'll put that in the handout.
Yeah.
Okay, so I like knockout points. I like technical points. Are there any others that I could use when I've received a summons?
Yeah. So criminal proceedings must be commenced by a person who is entitled under the Legal Services Act to conduct litigation. So
meaning a solicitor, I guess.
Solicitor, barrister who has the ability to conduct litigation.
And not all barristers can they? You have to get certification from the Bar Council that you're entitled to conduct litigation.
Exactly.
Right.
So, and it can't be an unqualified paralegal, someone who is even if they're subject to supervision within that firm, and everything that happens in that firm is run by the principal, the document itself must be signed off by a person entitled to commence legal proceedings.
And presumably a lettings agent can't do it?
No.
unless they happen to be a solicitor.
Well,
unlikely.
Yeah.
Okay, so that's nice. So there are 3 technical points there: the time limit, the contents of the summons, having to include any response that was received from the notice and any other particulars, and the person has to be someone authorised to conduct litigation.
Yeah.
Great. Okay, so let's imagine that the prosecutor has got past all of those points, and we are now going to think about proving our offence, going back to the topic of our webinar, proving the elements of an EPA prosecution. I'm going to guess, Andrew, you'll tell me if I'm wrong, but I'm quite sure I'm right, that evidence in a criminal case is just the same as evidence in a civil case, right? And it's a long time since I've done any, proper criminal cases, but from what I remember of my law studies, I'm sure the evidence rules are just the same, aren't they?
Well, it's a different world. It's like being on Mars, basically. So in the civil arena, hearsay is admitted, subject to notice, but hearsay in crime, there's a general prohibition with very technical exceptions about whether hearsay is admissible. Similarly,
so hang on a minute, just hold that thought. So if I'm a landlord and I want to just send along a housing officer to the trial, and the housing officer in their witness statement will say, here are all the records of the contractor who attended the property on the 17 occasions when the prosecutor failed to give access. And they have told me that on each of those occasions, they rang the doorbell and the prosecutor refused to open the door. Is that not good enough?
Well, I'm assuming that we haven't served a hearsay notice.
No, because, the housing officer's just telling the court what the contractor said to them. Isn't that good enough?
Well, no, because the purpose of the hearsay notice is to enable all the parties, including in this case, it's the tenant, but particularly the defendant, is to enable all of the parties to know exactly where the hearsay is and when it's being used for a hearsay purpose, and to challenge it. And to say, well, look, I want to see what he's actually got to say, rather than what someone else says that he's got to say.
So actually, I'd need to find out what the technical rules are about hearsay evidence and comply with them if I want to rely on the evidence of somebody who isn't going to attend the trial.
Yes, and it may well be in that scenario that there's a business records exception, which you can avail yourself of, but it's important to be conscious of all of the ways that you might want to use hearsay, and to get that right at the outset, because there's nothing worse than getting to trial and finding out that you want to rely on something for a hearsay purpose and you don't have your notice.
So I'm guessing there must be something like the civil procedure rules for the criminal cases, am I right?
Yes, the Criminal Procedure Rules 2020.
Right, so do they contain rules, those rules you were talking about hearsay, are they in the Criminal Procedure Rules 2020?
Well, it contains some of the procedural rules around the use of hearsay evidence, but it's largely common law.
Okay, so you really have to know your stuff and get it right. Okay, in the time we have left, we're going to talk about experts, right? We've said a few times during this chat that expert evidence is not just very important in EPA prosecutions, but if you're the prosecutor, it's absolutely crucial. You have to have it, right? I know, because you told me earlier, that in the Criminal Procedure Rules 2020, there is a whole part that is all about expert evidence.
Yes.
Right? I think it's checks notes, part 19.
Yes.
Okay, part 19. And that is a fully codified set of rules which encapsulates everything an expert has to comply with relating to giving evidence, producing reports, etc., in relation to a criminal matter, any criminal matter, including EPA prosecutions, right?
Yes.
Okay, so I think it's a bit dry, isn't it, all of this stuff? It would be like going through part 35 of the civil procedure rules and telling our audience each little bit of rules that applies to how to rely on expert evidence. I think that'd be a bit boring, and we can put the details into the handout.
Of course.
But perhaps if I just highlight some of the things that you really need to watch out for that are particularly different from the civil procedure rules. Firstly, it's worth noting, isn't it, Andrew, because this isn't something we're used to, that when a prosecutor in particular, but I think this applies to both prosecution and defence, and particularly when a prosecutor serves an expert report, which often they'll do with the notice of intended prosecution, because they'll often have got a report before they get even to the stage of serving a notice. When they serve the report, they have to also serve notice of anything that might reasonably be thought capable of detracting substantially from the credibility of the expert. It's like that sort of full and frank disclosure element that you have in criminal proceedings that you don't have in the same way in civil, right? So that's one thing that has to be done that's different. Also, as I understand it, the party that's being served with the report is entitled to ask for a reasonable opportunity to inspect the expert's records and instruments, right? So the sort of scribbles and their protometer and their humidity gauge and whatever else they've used, the defendant is entitled to seek to inspect, and presumably it's not going to be the landlord themselves. They're going to get their own expert and get that expert to have a look at those instruments and just check they're working, that kind of thing, yeah. Right? Then the other one that is really important, and this is very different from civil cases, is that an expert who produces a report must attend court, right, magistrates' court, to give oral evidence. Yes. That's actually in the Criminal Justice Act. That's not even in the procedural rules. That's a fundamental black letter law rule, that you have to attend as an expert to give evidence orally if you've done a report. The magistrates can give permission, dispensing with the requirement to attend, but it's quite difficult to get. And generally speaking, you'll expect the expert to attend. Yeah.
I mean,
right?
the sorts of circumstances where that might happen would be where there's agreement about what is within the expert's report.
So in other words, like maybe it's a joint report.
Yes, yeah.
And although another interesting thing is very much different from civil procedure rules, there is no power for a magistrate's court to order a prosecutor and a defendant to jointly instruct a single expert. There is an absolute right, which the magistrates cannot override, for a defendant and a prosecutor to each have their own expert. But if there are two co-defendants, which you can sometimes get if the prosecutor is suggesting that there are two people responsible, or two parties responsible for the nuisance, then the magistrates can order both co-defendants to jointly instruct an expert. But what the magistrates are not allowed to do, they don't have the power to do it. It would be ultra vires if they did, would be to order a prosecutor and a defendant to share an expert, right? So that's set out in the rules. It's not allowed. We've covered the last bit already, which is that as a general rule, it is necessary to apply for permission for an expert not to attend court if their evidence isn't disputed. Okay, so we've covered some of the rules. There are lots of other ones, and we'll put some stuff in the handout about that, but those are some really important rules about experts. Let's go back, Andrew, to something we were talking about before, which is what sort of expert. So we've got all of these rules. We know that the rules are pretty strict about the contents of reports and the dates and who must attend to give evidence and all the rest of it. But what sort of expert do I need to be looking for if I'm a prosecutor attempting to prove a state of the premises?
Yeah, well, the starting point is always the rules. And the rules provide that opinion evidence is inadmissible unless it's coming from, in the case of an expert, the opinion needs to be based on their knowledge or expertise.
Okay, so presumably if I'm an environmental health officer and I've got all the qualifications, that's straightforward.
That should be straightforward, yeah.
If I'm a surveyor that looks on the face of it like a surveyor that doesn't do EPA prosecution work, then I might have to do a bit more. I might have to put something into my report that explains my experience, maybe not qualifications, but my experience in dealing with cases of this kind, so that I'm not challenged successfully about my knowledge.
Well, yeah, and that brings up an important point, which is that the rules do provide that the expert's qualifications need to be set out within the body of the report. So when you're thinking about, does this expert report actually satisfy the requirements, you need to be scrutinising the qualifications and asking yourself, do I have any doubt about whether this expert can has got it right, or has enough knowledge and experience.
And what if, sorry to cut across,
to give the opinion. Yeah.
And if I'm the prosecutor and I get an expert report, and when I read it, it doesn't look as if they have the qualifications, and their experience seems a bit insufficient, a bit inadequate. Do I just plough on with that expert? Is there a risk in proceeding with that expert? Should I try to get someone else? What's my situation as a prosecutor if I've got any doubts about the qualifications or experience of my expert?
If you've got doubts about the qualifications of the expert, arguably those are matters that if you did proceed with that expert, you would need to disclose to the defendant when you disclose your expert report.
That was what we were talking about before, wasn't it? Well, let me just find my note about it. Anything that detracts substantially from their credibility has to be disclosed.
Exactly.
Rule 19.3. Right.
And I think self-evidently a lack of experience or expertise does detract substantially. The best option for you, if you are in a position where you look at the expert and you think to yourself, the person is either not qualified or insufficiently experienced or whatever, is to get another expert.
Really? So really, I want to be identifying any problems like that very early on, immediately, before I spend money on getting them to do a report.
Yeah.
First thing is, actually, does this person have the experience or the qualifications to give this report? Okay, so does that mean I'm always going to be looking for a doctor then, because a doctor is going to have the ability to assess injury to health, right?
Well, it doesn't need to be a doctor. You don't need to have medical qualifications to give an opinion about prejudicial to health. But you do need to have either those environmental health qualifications or be a surveyor who does that sort of work. Just touching on the scenario that we were talking about, where you get one expert report, it's no good because the qualifications aren't made out. That expert report doesn't just sit in the bottom of the drawer, that has to be disclosed. So
crikey. Okay, so really needs to be considered before you get the report.
Yes, yeah, exactly. So because it's relevant, it's come into your possession as a prosecutor. It's not like civil proceedings where you can get a without prejudice opinion.
Right.
You need to disclose.
Okay, so you really do need to be very careful about qualifications or experience before any report is provided to you. That puts me in mind, Andrew, of my favourite case relating to EPAs, which is Southern Simpson.
Sorry, I should just mention. Of course, if it's a draft report, that's arguably, you're arguably in a different scenario there.
But if it's a finalised report,
it's a finalised report that's signed off by the expert, and typically one sees it. Draft witness statements that are signed improperly or without having gone through edits that are necessary,
become disclosable.
Draft reports that are signed off as being true become disclosable, and that's particularly of importance because you don't want to be in a trial, and I've seen it happen, where an expert says, "Oh, well, this is the wrong version of my report." At which point everyone goes, "Okay, well, how many versions of the report are there?"
17.
Yeah, no, this is the wrong draft, but it's signed by you saying that's true and it reflects your opinion and stuff. So
why did you sign it?
Why did you sign it? Oh, I changed it because my solicitor said to do blah 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 blah, and then it's
and then the whole case falls apart.
Exactly.
Right.
Anyway.
So really, so this really underlines that all of the problems that could happen when you instruct an expert, you have to bottom all of those out before any report is written.
Yeah. And if you do have problems, get in touch with counsel who's going to...
Yes, and get some advice. Okay, so that brings me to Southwark and Simpson, case from 1999, which has a lovely phrase in it in relation to the issue of the expertise of an expert in an EPA prosecution. And what the judge said in that case was that the expert witness could only be a proper person to give evidence in this type of case if, in the course of his duties as a surveyor, he has taken the trouble to consider and deal with the relationship between damp and mold and injury to health. So that's quite nice, because it just shows you that it doesn't need to be a set of letters after your name.
No.
What is required is that he or she, in the course of their duties as a surveyor, has taken the trouble to do this work, consider it, and deal with it. So it sounds like it's something that could quite easily be resolved, as long as the surveyor understands, if it's not an environmental health qualified officer, EHO, as long as the surveyor understands that they have to explain their expertise.
Yeah, and it's also, what is good about that authority is that it enables a certain degree of self-education by the expert.
As long as it's set out.
Exactly, and it needs to be set out. And one, you will see within the body of the report, within the way that the opinions are expressed and the sorts of conclusions that are drawn, you'll see the evidence of the officer taking the trouble to consider and deal with the relationship between the issue and health. And
that's because they know how to do it.
Yeah, exactly. Whereas you should beware a case where someone just says there's damp, therefore there's injury to health.
That suggests that somebody perhaps has never been to an EPA trial and doesn't know what they're supposed to be doing.
Yes.
Okay, great. Well, should we do a bit of a summary? To finish off.
Very good.
6 points, which I think we've now covered.
Yeah.
Number one was?
The condition of the premises.
Testing you. Sorry, Andrew. Go on.
So the condition of the premises does not need to be something of disrepair. It just is outcome driven.
Okay. Injurious or likely to be injurious to health.
Yes.
Okay. Number two?
Person responsible.
Number three?
The person aggrieved. Doesn't have to be the tenant. Could be anyone else within the premises. Could be a child. Probably not.
And that must be the prosecutor.
So the person aggrieved brings the prosecution.
There has to be a notice of intended prosecution. That's the fourth one. What's the fifth one?
The fifth is the application can't be made before 21 days after the notice of intended prosecution.
And finally?
And then the nuisance must be in existence at the date of trial, which means having up-to-date reports which you can rely on to prove beyond reasonable doubt that there is a statutory nuisance at the time of trial and that the other side is responsible.
And if you don't want to lose a lot of sleep over your prosecution, be very careful in your choice of expert and in the work that you do to ensure that the expert report is compliant and complete.
Absolutely. It's the most important part.
Most important part. And if you are a landlord, it's a very fruitful area for attacking the prosecution.
Absolutely.
Okay. Very interesting. Thank you very much, Andrew.
Thanks, Iris. Thank you.
Great. Well, I enjoyed that. That was interesting. I know a lot more about EPAs than I did before we started.
Me too.
Thank you very much. Bye, everybody.